Chapter 12, Reality of Assent, presented by Kelly Herzick. In Chapter 12, we're going to review problems with assent that may render a contract unenforceable. These are problems with acceptance. First, we'll discuss what genuine assent is, and then we will discuss the four major defenses to assent: mistake, misrepresentation, undue influence, and duress. We'll begin with the definition of genuine assent. As you may recall from our previous lessons, for a contract you need offer, acceptance, and consideration, but sometimes there is a problem with acceptance. Sometimes there will be claims that the acceptance was not genuine, and therefore the contract is not valid. When there is a problem with assent, contracts generally become voidable, making it subject to rescission or cancellation. If a contract is rescinded due to lack of assent, generally the parties must be put back in the same position as if the contract had not happened. Parties have to return any consideration or items paid or their reasonable value. For services, it will be the fair value of the services performed up to the date of rescission. Good business managers need to aim for genuine assent in their business contracts and should be able to recognize the major exceptions to assent: mistake, misrepresentation, undue influence, and duress. We will begin with mistake. When entering into a contract, there needs to be a meeting of the minds. We've discussed meeting of the minds in previous lectures, but as a reminder, the parties need to have an understanding of the terms and conditions under the contract. They need to know what they're getting into and what they've agreed to. That's meeting of the minds. Sometimes parties think they're making a certain exchange for a good or service, only to find out later that the deal isn't what they thought. Parties can misunderstand either a fact about the deal or the value of what is being exchanged, and they may claim no meeting of the minds, no acceptance, no assent, and they attempt to invalidate the contract under this basis. In U.S. courts, mistake of fact is really the only way to potentially seek rescission. American courts are reluctant to invalidate a contract because the value of an item exchange has changed because the parties accept that risk. For example, if you buy a used car and you think the car is worth $5,000 and later you find out that the car is only worth $3,000, the court is not going to intervene in that kind of mistake. European courts take a broader approach to mistake and permit contract rescission for mistake of value when the mistake involves more than 50% of the value. It doesn't happen in American courts. Mistake of fact is really the only contractual defense. Mistake of law or mistake of value doesn't get you out of a contract. So what is mistake? Mistake is defined as an erroneous belief about the facts of a contract at the time the contract is concluded. When excusable mistake occurs, legal assent is absent. That means there's no meeting of the minds. Mistake is a defense to the contract that is based on a party's mistake of fact. It's not induced by the other party's false statements. Remember the implied term of good faith and fair dealing. If the parties are acting in good faith, mistake can still cause the contract to fail. Malfeasance by one party, such as making false statements, changes the dynamic, and the defense may shift from mistake to the other defenses to enforcement, such as misrepresentation. So the other party in mistake is usually innocent, and they haven't made a false statement or otherwise tried to induce you into the contract. Mistake can be unilateral or mutual. Unilateral mistake is a mistake of fact by only one party to the contract about a material fact under the contract. It has to be an important material fact. It can't just be something small, a technicality. It has to be about the core of the contract. The general rule is that unilateral mistake does not void the contract because courts do not favor voiding a contract when the other party has a correct understanding of the facts and is otherwise acting in good faith. They're not going to void a contract for one party's mistake when the other party was truthful and acted in good faith. Even unilateral mistake can justify contract rescission in some circumstances. There are exceptions to the general rule of no rescission for unilateral mistake. Any one of the following can be an exception to the general rule. There are three main categories, and any one of them is an exception. One party knew or had reason to know about the other party's mistake of material fact. The mistake was caused by a clerical error, not resulting from gross negligence. Or the mistake of fact is so serious that the contract is unconscionable, so unreasonable as to be outrageous. That last one is very rare in unilateral contracts. Most of the defenses are concentrated under the first exception, where one party knew or had reason to know about the other party's mistake of material fact. An example would be the conduct of the parties to a recurring sales contract. If the order amount suddenly varies substantially, going up or going down, this could be an obvious mistake the seller would have reason to know is a mistake by the buyer just based on their course of conduct. Suppose your business is selling organic produce and you have several customers such as restaurants and small grocery markets. One of your customers suddenly goes from ordering 50 apples a week to 500. Based on past conduct, you might have reason to know this is a mistake. In addition to unilateral mistake, there is mutual mistake. Mutual mistake is when both parties are mistaken about either a past or current material fact, and either party can then choose to rescind the contract. Mutual mistake of a key material fact prevents the parties from making a true agreement. There's no meeting of the minds. Neither party understands the nature or the terms of the contract. The classic example is the case of the two ships named Peerless. In that case, the parties agreed to ship cotton on a ship named the Peerless. However, there were two different ships, both with the same name, but with much different shipping schedules. Because one party to the contract meant one ship, while the other party meant the second ship, there was just no meeting of the minds on that material fact, and the court voided the contract. For mutual mistake, you must meet all of the following elements. It's not like unilateral mistake where there's three different exceptions. You have to have all of these at once to make mutual mistake. A basic assumption about the subject matter of the contract, a material effect on the agreement, and an adverse effect on the party that did not agree to bear the risk of mistake at the time the contract was made. For the first element of mutual mistake, the basic assumption usually has to be about the existence, the quality, or the quantity of the items exchanged. An example would be an assumption about the quality of carpet being sold when the seller puts the wrong tag on it. Both parties make a mistake in this situation. For the second element, it's not enough just to claim you wanted something different. It has to affect the very reason you entered into the contract. For example, the carpet you thought you were buying does not actually exist, and you would not have entered into the contract if you had known the company was actually selling you totally different carpet. For the final element, to avoid the contract, you must not have assumed the risk, such as buying the carpet as is, but later feeling the carpet was not worth the price. Now we'll move on from mistake to misrepresentation. Misrepresentation is different from mistake in that while one of the parties is in error about a material fact, the other party has made a false assertion about that material fact. This untruthful statement prevents the other party from having a meaningful understanding of the material facts of the contract, preventing the formation of a legal contract. On the surface, it may appear that the parties have agreed to all the terms in the contract, but the false statement prevents true meeting of the minds. There are three types of misrepresentation: innocent misrepresentation, negligent misrepresentation, or fraudulent misrepresentation. We'll begin with innocent misrepresentation. An innocent misrepresentation is a false statement about a material fact in a contract, but the person making the statement believes it to be true. They make the statement in good faith. The person making the statement lacks intent or knowledge that the statement is untrue. This is called lack of scienter. You might want to write that term of art down for testing purposes. If there is an innocent misrepresentation of a material fact, The deceived party can rescind the contract, but they can't sue for damages. They can be put back in the same position as if the contract never existed, but they can't get damages. A classic example of this is the family piece of original art for sale. Suppose a woman has a painting in her family for a long time, and family lore is that the painting is original. When she dies, her son becomes the executor of the estate. Relying on his mother's statements throughout the years, he lists it as an original piece of art in the estate sale. A buyer relies on the representation and buys the painting, only to find out it was a copy. Because the executor truly believed the painting was real even though it was not, the buyer can rescind the contract but cannot sue for damages. And this is because the representation that induced her to enter the contract was, while untruthful, was also not deceitful. In other words, the executor had no intent to deceive her about the painting's status. He truly believed that it was an original piece of art. Now let's talk about negligent misrepresentation. Negligent misrepresentation is a false statement about a material fact in a contract made by a party that believes it to be true, but is negligent in making the untrue statement. This means that the party should have known the truth if he or she made a reasonable investigation into the true facts concerning the statement. The other party can rescind the contract and sue for damages if he's harmed by reliance on the representation. The remedy here is the same for fraudulent misrepresentation, which we'll talk about next. So let's go back to our art example, and let's change the facts a little. Suppose the art could be very valuable, and in the circumstances, it would be reasonable to have the painting authenticated and valued before listing it as original in the estate sale. Once it's sold as an original, then the buyer discovers it to be a copy. The sales contract can be rescinded, and if the buyer has been damaged, he or she can sue for damages. And the reason that they can sue for damages is because the executor was negligent. It would have been reasonable before listing a valuable piece of art to have that art authenticated and valued before listing it as original. And because he didn't do that, he breached his duty of care. He was negligent, and so the other party who was harmed can sue both to have the contract rescinded and for damages. Next, we'll discuss fraudulent misrepresentation. Fraudulent misrepresentation involves an actual fraud in the representation concerning a material term in the contract. It can be an actual assertion, an affirmative statement, or an omission, which is a failure to say something. For example, it can be a concealment, where you're actively trying to conceal or hide a material fact, or it can be a non-disclosure, where you just don't say anything, but you know it's a material fact that would change the position of the other party. The innocent party is tricked into the contract by the fraud. The fraudulent misrepresentation is made intentionally or consciously to mislead the other party. The party making the misrepresentation knows the factual claim is false. It is also known as intentional misrepresentation. I tend to use fraudulent misrepresentation because that's what it is. It's an actual fraud. There are three elements to this type of misrepresentation. There has to be a false statement about a past or existing fact that is material to the contract. There has to be an intent to deceive, and then justifiable reliance on the false statement by the innocent party in the contract. This means that the injured party did not know or should not have known the statement was false. There's just no way for them to have found out that the statement was false. Let's go back to our art example. Suppose the executor knows that the painting is a 19th century copy of a 16th century original. However, he intentionally lists the painting in the estate sale as an original 16th century piece of art and then creates a false valuation or authentication. If the buyer reasonably relies on the false statement and on the false appraisal, but later finds out that the painting is really a copy, he can rescind the sale, and if he has damages, can also sue for them. So at the end of the day, when there's fraudulent misrepresentation, if the party had no way to find out that the statement was false and justifiably relied, then they can sue to rescind the contract, and if harm results, sue for damages. In addition to an affirmative representation, an affirmative statement, fraudulent misrepresentation can be found if there is an active concealment of the truth or an omission or a non-disclosure. Concealment involves the act of hiding the truth, such as rolling back a car's odometer from 70,000 to 20,000 and then telling everyone it's a low mileage car. Non-disclosure is an omission, failing to provide pertinent information. Omissions are the failure to act or the failure to say something when one has a duty to speak. Concealment is hiding the truth from another and involves action. Omissions are inactions like knowing something is false but not speaking up, which allows the other party to be tricked. On the other hand, concealment involves some kind of affirmative action. That's the difference between the two. These can be fraudulent misrepresentation if a relationship of trust exists between the parties and there is a failure to correct assertions of fact that are no longer true in light of events that have occurred since the initial contract. For example, failing to correct an assertion that a house did not have termites, which may have been true at the time it was made, but is no longer true because they found out that there were termites during an inspection. We'll end this lesson with the last two exceptions to assent, which are undue influence and duress. Undue influence involves a situation in which a party uses their power to take advantage of his or her dominant position in the relationship to persuade the other party to enter into a contract. The use of undue influence interferes with the other party's ability to make his or her own true decision. Bargaining with an attorney, a doctor, a guardian, a relative, or another person of influence or power over you often puts pressure on a person to agree to something that they might not otherwise do. That's why it's called undue influence. This is also seen in the wills and estates area of the law. An example would be persuading an older relative to leave you his estate over other potential heirs. Those heirs might argue that you exerted undue influence on that elderly relative and that the elderly relative would have split their estate between the heirs except for your undue influence. Duress, on the other hand, is an active interference. It's a wrongful act that forces another to enter into a contract. For example, threatening physical harm or extortion if they don't sign the contract. Threatening to file a criminal case unless consent to the contract is given, or threatening another's economic interests, getting them fired if they don't sign this contract. Generally, duress can be based on criminal activity, particularly threats of bodily harm to another. Threatening to file a civil lawsuit against a party is not duress unless the suit is frivolous. That is the end of Chapter 12.